All right, so welcome. This morning we're rev up week 9, and we're talking about the listing agreement. So welcome to Rev Up. Thank you for hanging in there, for leaning forward and building your business. Now, before we talk about week 9, the listing agreement, who can tell me what we discussed last week?
We talked about the different types of loans between VA, FHA, USDA, and conventional with David Cooper, I believe that was his name.
Absolutely. You got it. We also talked about some down payment assistance programs, right? So yes, great job. So thanks for recapping that for us. So Module 9. So here are the learning objectives for this morning. So we're going to talk about the seller representation agreement, which we call the listing agreement. We may hit just briefly on agency disclosure, MLS listing forms. We're not going to spend a lot of time on that this morning. And seller disclosures as needed. We're not going to talk about counter offers or multiple counter offers, as we've already had this in a different session. However, if this were a standalone session, we would hit it again. So, all right. So the one crucial thing you need to remember is you need to complete the listing agreement, the listing packet, or the listing paperwork. And what you want to do is you want to make sure that you read all of your forms, all of the agreement. It is crucial that you understand what each clause means. So the reason is because when your client has a question, you don't want to sit there and look like a deer who's blinded by the light when they ask you a question about something on the agreement. And we'll go over that in just a few minutes. And your ability to, I'm going to say summarize, not explain, okay? Your ability to summarize the contract to your clients will give them confidence in you and the process. And you need to practice writing these listing agreements with a variety of property types. There are different nuances that will fall into the listing agreement based on the type of property that you're going to list. Now, what I'm going to do is I'm going to change. Let me see if I can get this right. Okay. Can everybody see my listing agreement?
Yeah, we're good.
Well, yep, you'll have to unmute to answer me, sorry.
Yes.
Okay, let's see. Is that too little, or do I need to go back and minimize?
It's small.
Yes,
How about that?
Yeah,
Okay.
that's fine.
All right, so you guys help me along. And if you can stay quiet, stay unmuted, but if you got noise in the background, go ahead and mute yourself. So whenever someone, one of your clients, you're talking to them about selling their property, and we're going to go with a single family property this morning and just make it cut and dry as to what kind of property we're listing. We're listing a single family. So we want to make sure that we download the proper listing agreement. So if you look at the top, the name of this is exclusive right to sell listing agreement. If you'll go down to the bottom right of the form, you'll see it's called a standard form 101, and it was revised May of this year. So that tells me that I have the latest and greatest, the updated form, okay? Now, I will tell you, this is a live listing agreement that I have. It does have some information on it, so don't be making copies, taking notes. Sorry, I should have went and redacted some of this information, but I'm sure my client will be fine with me using it as a teaching tool. But nonetheless, just make sure you don't snap a picture of it. Keep it for yourself. Okay. All right. So we have already signed our agency agreement. We're not going to go back over that again right now. We're going to spend a little bit of time going through this form. Now, who can tell me why this form is so important?
So you get paid.
Who said that? That's awesome.
Lane.
Okay. Yep. That is one reason. What is another really important reason why this form needs to be filled out and signed by all parties?
So another agent cannot scoop them up.
Okay. Protect your listing. Okay. Actually, the agents, yep, along with the agency, well, the agency part of it. So yes, you're right. All those are good answers. And really, the answers are a little complex when it comes. So we'll kind of flesh it out as we go through this form. But I look at this form as your hiring agreement. This is a hiring agreement between your firm, Realty One Group Revolution, and your client. It's not between you and your client. It's an agreement between your firm and your client. So keep that in mind. This belongs to the firm, okay? Now, as we go through the top portion of the form, you want to make sure, at least I do, that I have the legal name that the attorney is going to use on the deed. That is what I like to use on my listing agreements. And most cases, the first name, middle initial, and last name, as well as the secondary party. And in most cases, I didn't do it here. I would put in parentheses out to the right, married, if they're a married couple. Now, so you want to spell out who the listing agreement is between your sellers and your firm as the listing firm. Now, if you'll look at that paragraph right under the listing firm, it says the individual agent who signs this agreement shall, on behalf of the firm, be primarily responsible for ensuring that the firm's duties hereunder are fulfilled. However, it is understood and agreed that other agents of the firm may be assigned to fulfill such duties if deemed appropriate by the firm. Can someone tell me what circumstance might arise where the firm would take this agreement and give it to another agent, or allow another agent to list the property and see it to close?
Would that be dual agency? No.
If,
Yeah, but that's,
It's when you're representing both sides, right? They would give it to a,
we're not talking about dual agency here. We're talking about a
If-
listing agreement.
if something happens to the,
Okay, I'll tell you guys. As the broker in charge, if you're in a dispute with your client and they are wanting to walk away from your services and or our firm, as the BIC, I can step in and reassign this listing agreement to another agent. Okay? Just keep that in mind. Now, we're not going to talk about commission. That's another issue, but I want you to know that the listing agreement belongs to the firm. So ordinarily, this doesn't happen. Probably in my 14 years, I've only done this about 4 or 5 times. But in the end, that is something that the firm can do should they choose to do so. All right. Now there's a big box that says note right here at the beginning. So why do you think this box with the blue outline that says note is sitting right here for you?
something you should pay very close attention to.
Absolutely. Would somebody like to read this quickly?
Yes, note, if the property was most recently owned by a person who is now deceased, the tax listing or last recorded deed to the property may not accurately identify the party or parties who should be named as seller. In such a case, the deceased owner's will or applicable North Carolina law if the deceased owner died without a will determine the correct party or parties to sign this agreement. Advice from a North Carolina attorney should be obtained concerning the proper parties prior to completing this agreement. If the
Okay.
owner of, oh, sorry.
Okay, hold up just a second. Okay, good. So it's giving you scenario number one. If this scenario is in place, you have a deceased homeowner. It tells you how to go about the process. Okay, whose name to list it in. Okay. All right, read the second paragraph.
If the owner of the property is the corporation, limited liability company, trust, or other legal entity, the entity should be named as seller and a duly authorized officer. Manager, trustee, or other legal representative of the entity should sign this agreement on the entity's behalf.
Okay. All right. So that's the second scenario. And then the third scenario is the last paragraph, if you'd like to read it.
A non-owner spouse should be named as seller because he or she will be required in most cases to sign the deed to release certain marital rights in the property. If a married owner has signed and recorded a prenuptial agreement, postnuptial agreement, or a free trader agreement, consult a North Carolina attorney to determine whether the non-owner spouse will be required to sign the deed.
Okay, so if you come up and you're talking to your seller, you're ready to list their house. However, these are three questions that you might have. Just remember to go back and read this note in the box. If one of the owners is deceased, if any of the owners are part of a corporation or company, or number three, if there's a non-owner spouse, meaning they got married after the property was purchased or whatever. Remember, go back and read these notes, okay? Now, when you're selling property in North Carolina to two people who are married, what do you think should go on the listing agreement?
I
Both
missed
their
that
names.
question.
Both of their names, yes. Okay. Because if you look down here, whether that spouse owns the property or not, they're going to be probably have to sign the deed. And in that case, that's where we would talk to the attorney. But nonetheless, put both names on the listing agreement. Okay. All right. So now we've determined who the listing is between, the seller and the firm. And now under the box, it says in consideration of firm services and efforts to find a buyer for the property, firm is hereby granted exclusive right to sell the property on the terms and conditions as set forth in this agreement. So now here's the terms of our agreement, right? So 1A is the term. The effective date is when? Okay, y'all got to answer quick. When is the effective date?
The date that both parties sign.
Or it's right here, A and B, right?
Mhm.
It's either when both parties sign or unless you check B, the effective date. I'm sorry. Okay. So, okay. Let's back up. A, the term shall begin on its effective date and shall end at 11:59 p.m. on its expiration date. So that's the start and finish, okay? The actual effective date shall become effective when either both parties sign, or look at this other box. The property is currently listed for sale exclusively with another real estate firm. Seller represents that the current listing agreement expires on blank. The effective date of this agreement shall commence immediately upon the expiration of the current listing agreement. Okay? So it's one of those two options. Most times, right, it's the top one. You got to be very careful about the second box because we're not supposed to market to another client who is under contract with another agent, or who is, in agency agreement with another agent. So that is not gonna be the standard on the second one. Okay. All right. And then the subset C, the term of the agreement, the expiration date, make sure anywhere you see a blank, you probably need to put something in there. So we need to put an expiration date. So for my listings, automatically, I go 6 months out. Why? Because we're probably going to be on the market 30 to 45 days. And instead of after 2 months, trying to get something else signed again, I just punch it out 6 months. None of my clients ever argue with that. So, all right. Now that brings us down to number 2, the property information. What goes in these blanks? Now, we're going to skim through this. So the street address, of course, the city, the zip, the county, and guess what goes down here under legal description? The legal description can come, and in North Carolina, we always want to try to put the property identification number, which is found on the tax record, and the other description, which is the actual legal description. Okay? So in other description, you're going to put the legal description. On the PID line, you're going to put the PID number. Now, that last line here, property deed book, this is important because when the attorney goes to do title search, that's where they're going to pull their information. So you want to make sure you have the deed book accurate and then the page number on the second line. Don't get them reversed, okay? Now, a good attorney is probably, or paralegal, they're going to catch something if it's not right, but you don't always want to rely on that. This is your paperwork. It should be right. So is everybody good on where they get this information?
Where do you find the other legal description?
So go to the tax record, and if you scroll down, I didn't pull that up, but it's in the tax record.
Okay,
Legal
great.
description. Okay. Where else could you find this? Somebody that pulls.
Register of deeds.
Register of
Under
deeds.
registered deeds.
Right, yes, but what documents? Where else online can you find this other than just a tax record? When you go to search a property plot, where do you go to a lot of times?
I have no idea.
I know Michelle knows. It's your map. Union County,
Yeah, it's the GIS or the,
yes, yeah. Okay. All right, good. All right, so on the bottom of each agreement, just remember that you're representing the firm, so your initials have to go down here in this individual agent initials box. As well, your sellers, whether there's one or two, if there's two, you got to have two initials, but make sure the bottom of every form is initialed. Now, number 2, again, we have this blue box again with a big note. And that means you really need to read this and advise your client. So the note basically says the following paragraphs 3 and 4 are part of the offer to purchasing contract, a form which is commonly used to put residential real estate under contract in North Carolina. It is highly recommended that seller and the individual agent who signs this agreement discuss in detail and describe in writing in paragraphs 3 and 4 what items seller is willing to convey as part of any sale of the property, and what items the seller would like to exclude from any sale, and what items located on the property that seller may not own. Okay, what is seller giving up with the listing? What are they taking away? And what do they not own? These are huge, and it needs to be listed in this listing agreement, okay? Again, this is agreement between you and the seller. If you get in a dispute later where a buyer wants some personal property that the seller has, you always refer back here. And the listing should reflect what is on the listing agreement. Now, what is it referring to? This number 3, fixtures and exclusions. In real estate school, you learned what a fixture is, right? Everybody head nod.
Yes.
What is a fixture?
Permanently attached.
Okay. All right. Look, when you're reading this, when you're summarizing this listing agreement as your other contractual agreements, don't get into the habit of trying to explain what this is, because you're gonna skirt the gray areas of practicing law, and you don't want to be accused of that. You want to paraphrase what this says. So if you just read this to them, you're golden. You know, a lot of times we don't want to just sit there and read a form though, but we can paraphrase. So if you look at subset A, fixtures are included in the purchase price. Remember that fixtures are included in the purchase price unless. All right. Now the unless is in the subset D and E, but let's go down to item B. What are some specified items? Now this is the list of things that you might want to go through and let your client answer and say, are these going with the sale of the property? Don't advertise garage door openers unless you've seen them and know that they actually exist and will go with the property. Otherwise, guess who's going to be buying garage door openers at the end of the sale? Okay. Some other things, basketball goals, if they're permanently attached. Here's kind of my thoughts on anything that's a fixture that the seller is questioning whether or not they want to leave with the house or not. Before you list the property and take pictures, that fixture in question should be removed and either replaced with something else or covered up. For example, if you have a chandelier that's a family heirloom that is hanging in, I was going to say lobby, not the lobby, but hanging in the front entry of the house, you don't want to go under contract and take a chance that the buyer wants to argue with keeping that. Don't even let them see it. You take it down before you list the house if it's going to be an issue. The alternative is to list the property and disclose that that chandelier is not going with the sale of the property. Okay. I will tell you though, if it's that important to the seller, I would say take it down, replace it. I've had sellers pull out stoves and replace them with a different stove. I've had them pull out all sorts of stuff. But if they want to keep it, make sure they pull it out first and don't market it. I actually have seen listings where agents who have they've had pictures taken, and then after the pictures were taken, the client removed the stove or whatever fixture it was and put a different one in there. And in the end, the buyer was able to have that removed and the original put back, because usually a seller in that circumstance is trying to remove the higher priced item and replace it with a more inexpensive item. And that is not cool. Can't do that. Okay. All right. So if you advertise it, if you disclose it, that's what you need to sell. Any questions there? Okay, let's move on. And something that's fairly new to this listing agreement, you'll see at the top of this next page, subset C, unpairing or deleting data from devices. Why do you think that should be necessary now?
All the smart devices people have now. Garage door openers can be opened by phones. You can control Nest and heating and air conditioning and all sorts of smart devices that you want to make sure and unpair.
Absolutely. About a week ago, I was moving my daughter's car, and I got in and cranked it up and backed it out of the garage, and I heard these voices. I'm like, somebody's talking. And I didn't realize she had her Bluetooth on in her car, and I could hear her and her boyfriend talking on the phone. So I'm sure. You know, privacy reasons, to protect yourself and your clients, you want to make sure that you have a talk about unpairing devices that are, you know, at this point, there's no telling how many devices the average household has that has some kind of remote or wireless access. All right.
Hey, Tommy,
Yes.
just kind of an FYI, as far as I know, it's this way in Utah, and I'm assuming it's the same in North Carolina, but just FYI for sellers, if they have any cameras inside their home, it isn't, I don't believe it is legal for them to record audio, like sitting and listening to buyers that might be in their house and listening to conversations. I think that's illegal.
Right. And I'm
So that
trying to
might be a
remember
conversation
if
to
we
have
have
with
something
sellers
on
at
this
this point
form.
with all the listing stuff.
Yes, absolutely right. And look, the law is never black and white on cameras and recordings anyway. So what is good today probably won't be good tomorrow. So if there's even a question, I would tell my clients, please do not record anybody else in your house without their knowledge. Okay. Sometimes you can go into a property and there'll be a sign on the door or in the living room that says, camera is on or something like that. I don't know. I'm just that old fashioned guy. I just think people can sue you for anything. I wouldn't do it. Same thing with listening devices. I just don't think it's right to let people in your house to preview a property and then eavesdrop on their conversation. So anyway, be careful with that. Yeah. Thanks, Michelle. Now, one thing we want to remember is any item that is not owned or could be leased by the homeowner should be disclosed right here in subset D. What are some examples? You can see them right here in the form.
The satellite dish, for sure.
Yeah, what is something new or something that's coming back as an energy source?
Solar panels.
Yep, solar panels. This is going to be a big issue again. Who owns it? Disclose it. Back in, I don't know, 10 years ago, it seemed like every house, at least in Union County, had a satellite dish on it. Not so much today, but just remember, if there's something attached or something that's part of the property that's not owned by the seller, you need to disclose it here. In a rural area, what's something that might be in the backyard, but the seller does not own?
Is that the
Oil-
propane tank?
Yep. Propane or oil tank. Yep. Okay. Now, E, other items that do not convey. What do you think would go here? It tells you, identify those items to be excluded under paragraphs A and B. Okay. Now, if there's nothing here, put in A. You don't want to leave any blanks. All right. Now let's move down to number 4. Personal property. This is huge. And a lot of times, especially newer agents, they forget to talk to the lender about personal property or the transfer of personal property during the sale, and they get in trouble. But if you fill this out properly, the lender is going to see it. So number 4, personal property. Why do we want to make sure that we list these items here? That big old note right here gives you a clue, right? Any personal property would be part of the sale should be identified in this paragraph. Now, a lot of times we get under contract with somebody and then the seller will come back and say, hey, Mr. Buyer Agent, my seller's in a hurry. They don't have time to pack everything up. So would your buyer like to have the horseshoe pit, the swing set, the trampoline, the fire pit, those types of things? If they didn't make it on this personal property, there's another way to do that to transfer those up. But I would say that would need to be a separate transaction. Don't make it a transaction to the purchase. Okay.
I mean, I have a question. So this
yes.
is where, like, for instance, we had a rental house where someone did this, where they left stuff. So this is how, like, say, a trampoline or how you could get around someone just leaving a bunch of junk?
Well, if they left stuff, that's different. That's also in, I like to say violation of the agreement.
Oh.
Because any seller is supposed to remove their personal property before they vacate the premises or before the sale is closed. That's different.
Okay,
But if you asked, or there was an exchange of property as part of the sale, it needs to go here under personal property. And it needs to be noted that it transfers at no value, okay? But yes, I would treat that differently if a seller left a bunch of stuff and didn't take it with them. That's not something, there has to be mutual agreement here between the buyer and the seller as to what they want. If somebody's trying to push something on somebody, but they don't want it, then it's not part of the sale.
okay.
All right. So make sure, and on the refrigerator, if it's a stainless steel or a particular brand, I will put that in there. Particular washer and dryer, most times I usually do that, but these were older appliances. Number 5, the home warranty. Is the seller willing to purchase a home warranty up front or not? And if they are, disclose it here. The listing price, and make sure, and I don't know, I don't think DigiSign caught all my boxes because I know I checked FHA and VA on this. Anyway, make sure the listing price, this is between the firm and the seller, make sure you put the price that you guys have agreed on, okay? And the types of financing available. If it's an older house and you know it's not going to make an FHA loan, don't check that FHA box, okay? Now, the firm's compensation. This is where you have discretion. At Realty One Group Revolution, we don't dictate the commission that you charge. However, I would say be careful discounting your commission. Try to keep your commission intact. This happens to be an agreement between myself or the firm and a client that I've done multiple transactions with. So I gave her discount on the listing fee. And if you go down here, and we're not going to go through it, but how is the fee earned? There's subsets 1, 2, and 3. And on subset 3, if you'll notice in this box, I put 120 days. If the circumstances set out in or above have not occurred, and within 120 days after the expiration date, seller either directly or indirectly sells, options, exchanges, conveys or transfers or agrees to sell to any person with whom the seller firm and cooperating real estate firm communicated with during the transaction, then they owe us a commission. Okay. So make sure you don't leave that blank. Okay. I put 120 days. Some people put less, maybe some people put more, but anyway, there you go. So that's a protection clause. All right, let's move into page 4. It talks more about the fee being due and payable. You should go there and familiarize yourself with this verbiage. Subset D, the transfer of interest in a business entity, meaning if the seller is part of a corporation, and if they are a house flipper or investor, you want to make sure you read this. Additional compensation. Let's look at this right quick. If additional compensation, including incentive, bonus, rebate, or other valuable consideration is offered to the firm from any other party or party in connection with the sale of the property, seller will permit firm to receive it in addition to the fee. Firm shall timely disclose the promise or expectation of receiving any such additional compensation in firm and confirm the disclosure in writing before seller makes or accepts an offer to sell using the form NCAR 770, okay? Make sure that if there's any additional compensations to what you've agreed with the seller, you've included them in that additional form 770, okay? Can't take money that's not disclosed here. And subset F, attorney's fees and costs. If firm is the prevailing party in a legal proceeding brought by firm against seller to recover any or all fees, Firm shall be entitled to recover from seller reasonable attorney fees and court costs. Okay, so that's included. Now, are you going to go and read all these line items to your seller? If you were to read this verbatim, they'd probably be scared to death to sign this thing. What you want to do is be familiar with this in such a way that you know how to carry yourself and you know how to condition them and know how to summarize this to make them feel at ease with you and your services that you're offering them. You can sell their house. Okay. If they have specific questions, you can go back and answer using this agreement. Number 8, your compensation agreement to other firms. You want to make sure you check one of these boxes, and we recommend you check the middle box, working with buyer agents, and you need to disclose the commission amount that you're willing to give the buyer agent on the other side that will also show up on the listing on the MLS. Okay, this is big. Make sure that whatever this fee is, that it shows up here and in the MLS. And then basically we're going into number 9, the firm duties. When I talk to my client, I in about 6 or 10 seconds, I summarize how we help them, what our duties are, helping them find a buyer, disclosing all material facts, professional services. And again, disclosing the material facts means they need to cooperate with you in letting you know everything that you need to know about the property. Okay. Or if they choose not to, on the residential property disclosure, and we'll talk about that maybe later. Okay. So if you go through those, basically outlining the firm's duties, and then we get to the statement that's in bold. Again, if it's in bold or if it's in a box, you probably should read it, right? Would somebody like to read? Actually, somebody paraphrase that for me. What does this mean right here? This one bold paragraph. You can say it in 2 or 3 words.
There's no discrimination.
Absolutely. Absolutely. That's reminding us and our client, we're not going to discriminate. Now, I forgot to get my seller to initial something right here. What does this statement mean? Seller acknowledges that seller has been made aware of each firm duty as described above in this paragraph, and there should be initials right here, right? So I got to go back and get her initial that, okay? And make sure all these are initial signed appropriately. Now that gets us into the marketing of the property. How we submit it to the listing service. This is basically paraphrasing that. When are we going to market the property? When it's under, when the agreement is ratified or at a later date. So it just so happens that for this particular listing, I chose B because they didn't want to market it when they signed the agreement, but at a later date. So a delayed marketing. So tomorrow, okay? Otherwise, the marketing can start when the agreement is signed. Then there's another box. It is in the best interest of most sellers to get the highest possible price or the best terms for their property. Yada, yada. So the way we go about doing this or what we do to help them will maximize what they get for their property. So thus, how we market the property. You want to make sure that you get all the authorization possible to market the property, including signs, open houses, internet. Coming soon is a different animal. We're not going to talk about that here today, but coming soon is a lot different. If you were to check coming soon, some other things would come into play here. But this is not a coming soon listing, so we're going to skip that right now. Internet advertising. If you want to do anything on the internet, this block should be checked. If you plan on doing an open house later, check that box now. If for some reason they say, I just don't want people in my house, it's a COVID thing, then don't check the open house, don't have an open house, okay? You have to abide by the seller's wishes. Okay, next page. There's a note up at the top. NCR Form 105 may be used to limit or prohibit internet advertising, explains how limitations may or may not be effective, okay? So if there's just that type of client that's real queasy about having their house on the internet, then you might want to go read this form. Okay. And also you're going to check lockbox because we need a way to secure the property and allow other not homeowners, buyers agents and their clients in. And then subset D, the seller acknowledgement. You're going to make sure they understand and cooperate with you in this way. Okay. All right, Michelle, here's that box that it's in red instead of blue. So maybe red is more time. Maybe we should be looking at it closer than we do the blue. So who would like to read this red box? I would just read the first 4 or 5 words.
Okay, I will. It may be a crime under federal and state laws to listen to or record an oral communication through the use of any electronic, mechanical, or other device without the consent of a party to that communication. Okay.
It says it may be a crime. Okay, again, like I said, whether it is or not is a red flag, and you should heed this. And if you read the rest of that statement, if there is a video audio surveillance device on the property, sellers advise that no audio surveillance device may be turned on during any showings, open houses, investigations, examinations, or inspections of the property, and that the placement of any video surveillance device should not violate a visitor's reasonable expectation of privacy. Okay, so there you go. Let's stay on the straight and narrow and advise our clients. If we think this is an issue, this is not something I'd come out and just say up front, but if they do have these devices out, I'll just make sure they understand. Also exclusive, this is not an office exclusive, so that's not checked. The next thing we talk about here is earnest money. And basically I tell them our firm does not hold earnest money. The earnest money is held with the other firm or the attorney. And I highly advise you to use an attorney to hold earnest money, okay? Don't want to get in a dispute with another firm who doesn't want to release. It's always best to have earnest monies with the attorney. And then we have seller representations. Is it in a flood hazard? How do we know if a house is in a flood hazard or not?
You can look at, there's a flood map, right? The FEMA flood map.
You can do that. You can call your insurance agent, have them pull a report. What's it called? Does anybody remember? Because I'm drawing a blank. Okay, I'll try to find that information, but yes, you can call an insurance agent, have them look up the property and see and verify if there's any flood insurance. Okay. All right, so synthetic stucco, it's usually pretty self-explanatory, but sometimes people will cover over things. You just want to make sure you go through these questions and get an answer. So not available. Owners association, if there is an owners association, you'll make sure you have the contact person's name, phone number, maybe email, the website, and any other pertinent information that will help you close this the sale. If it's new construction, you check that box. Okay, what is this thing about termite bond? So if a client, if your seller has an annual termite treatment that they purchase for this property, that's a termite bond, and you would check that and get a copy of that and hold it in the file. If they don't, then just check no, and you're good. Usually these termite bonds can transfer to another seller for an additional fee from the company, or sometimes they don't charge them at all. So what this is more of a peace of mind, kind of like the home warranty that, hey, this property is already being treated for, you know, termites. I mean, not treated, but precautionary treatment. Does that make sense to you guys? Okay. All right, subsidy ownership. Make sure that you know or have checked one of these boxes, okay? And then we look at the liens. Does the house have a payoff? If it is, who's the lender? What's the information? Sometimes there's more than one, put them. And then we're going into the question of whether or not they have contemplated bankruptcy or under bankruptcy. You should just ask these questions point blank. Don't assume. Is there a lease agreement in the property? Sometimes people will have leased a bedroom out of their house to a family member and had them sign something. This particular property has been a rental. So I checked the property is under lease, and here's the property manager's contact information, okay? FHA appraisal, to sellers' knowledge, there has not been one on the property. I want to make sure one of those boxes is checked. Special assessments, what is a special assessment? And why would we want to know?
Oh, it's where they charge, the HOA charges everyone a fee to do something like repave the sidewalk, or I don't know. And then that would transfer to the next buyer if it wasn't agreed upon for.
Good. Yep, that's right. Most cases, this is a new community or a new subdivision. The first couple of years, these assessments are levied on the homeowner. So the seller should be paying for these assessments. Now, a buyer would want to know if there's a special assessment coming, right? Because you don't want to close on a house and then 6 months later get a bill for, $2,500. So contact the HOA, developer HOA.
Tommy, can I ask a question about that lien section where you said you fill in like what the liens are in the house? Like, where do you get that information? Would you trust the seller to tell you that correctly, or
Yep.
do you actually go to their like say Flagstar Bank or whatever?
I have them give me a copy of their mortgage statement.
Oh, okay.
Put it in the file. You need a copy in the file.
Okay, great. Thank you.
Yep. Now, after special assessments, is it a manufactured home? If so, then there's information that'll go there. If not, I didn't put in A. But then you go, is there a fuel tank on the property of this, on this property? Yes or no? And if it is, you want to specify the location. And then we're moving into seller duties. I would just paraphrase this to them, kind of go through them. This is what I need help from you in making sure that we get the appropriate information so we can sell the property. And basically, well, let's look at this other note. If any sale of the property may be a short sale, consideration shall be given to attaching the NCAR Form 104 as an addendum to this agreement. That's just a note to let you know that if it is going to be a short sale, we're not going to talk about short sales today, but you might want to attach or look at NCAR Form 104. Okay, home inspection. Does the seller want to provide a home inspection up front? Most times, no. Photographs and other materials. You might want to just have a conversation about the photographs are going to go on the internet. They're going to go on the MLS, so their property is going to be out there. And then we move into some of the closing areas of the listing agreement, number 16. Additional terms and conditions. What do you think might go in here? Any nuance between you or the firm and the seller about how this is to be listed or sold would probably go here. In the past, I have given a commission rebate. I would put that here. There's not a lot. I wouldn't get creative here, okay? Because we're not supposed to be practicing real estate. But if there's any additional terms and conditions between you and the seller, that's where this would go. I don't know. Has anybody put anything in here or used this? Okay, no, okay. Dual agency. We want to talk about dual agency a little bit because we want to let them know if we get their house listed and somebody else from our firm, Realty One Group Revolution, comes up with a buyer, then we want to make sure we have dual agency so we can keep on working together, okay? And we're not going to talk about dual agency today, but make sure this is where they initial, okay? And there's a note here. When dual agency arises, an individual agent shall not practice designated agency and shall remain a dual agent if the individual agent has actually received confidential information concerning a buyer client of the firm in connection with the transaction, or if the designated agency is otherwise prohibited by law. So just some things to keep in mind. Mediation, if it ever comes to it and you need to talk to your client about mediation, here's a little clause about how that works. And then we're going to end everything with wire fraud because attorneys really are big on this. And it's about transfer of information and money. So you might want to be familiar with this. Most attorneys won't email wires anymore, right? And then the last page here is your signature pages. You're going to make sure their full name, information. If they're an entity, a business entity, this is where they would fill it out, sign, and then your information. Couple things here, make sure the firm name, the firm license number, and your phone number. Now, if you're a PB, the firm number needs to be right here. And then your agent number goes down here at the bottom. Put your office address, your license number. Basically, all these blanks are filled out. So on a listing agreement, make sure all these blanks are filled out in the end. So this is your listing agreement. It's not the shortest form in the world, but once you get used to going through the different blanks and filling them out, it will become more of a habit to you. But what I want you to do is I want you to make sure you question every blank. Don't assume anything, but when you see a blank, question what goes in it. Think about it. Do I need to do something different here? Do I need to ask my client another question? And I want to end today with the one habit. Who can summarize what the one habit is for us?
Three calls a day, add 3 people to your database, and 6 handwritten notes.
What happens when you do this by habit?
You build a strong business.
Absolutely. So if you're adding 3 people a day and you're working 5 days a week, that's 15 people a week, right? 15 times 4 is how many? 60. Do you think you're going to sit down in a day or two and call 60 people? I don't think so. But over a month's time, you connect with 60 people, you're really going to scale your business. I'm telling you. Do these small things, 3 calls. Don't even think about working 5 days a week for those of you who aren't doing anything at all. Do 2 days a week. So make 6 calls, do 6 ads and do 12 notes. Get into the habit of doing something to where you're adding to your database and connecting with people out there. You have family and friends out there who know, love, and trust you, but they don't know how to connect with you in real estate because you've never tried to connect with them. Okay. So let's get out there, let it be known. And I'm going to bring up, let's see, any final questions? I know we kind of breezed through the listing agreement. The purpose wasn't to go through and explain everything, but to give you an idea how the form is to be filled out.
I have a question.
Okay.
So, and I didn't know how to answer this question from someone that I actually have a neighbor who's ready to list her